Thank you very much, Mr. Speaker and honorable members of the Senate. Indeed, speaking for us, this is a very momentous occasion in our history and must be recorded as such. The United States of America is 248 years old since its independence, and for that entire 2.5 centuries, no Vice President of the United States has undergone a process of removal by way of impeachment. In a way, we are making history. And for me, it is such an important occasion for the 13th Parliament and this Senate that it will go down in the annals of history that the first impeachment of a deputy president in the Republic of Kenya was undertaken by this particular Senate. And we come here with a lot of confidence that the Senate is not new to the process of impeachment as understood under our Constitution. Indeed, the Senate has handled so many impeachment proceedings in relation to the offices of governors and deputy governors. And more importantly, that this Senate has been a great contributor in establishing the jurisprudence revolving around the impeachment process in the Republic of Kenya. Many of the cases that have gone for determination in our system of courts, High Courts, Court of Appeal, and the Supreme Court have involved the participation of the Senate. So as we address you today, we are not addressing a chamber that is dealing with a novel idea. Indeed, by dint of Article 10 of the Constitution, which requires all state organs and state officers to make any decisions or apply the law and the Constitution, they are required to apply the Constitution of the Republic of Kenya. That is by dint of Article 1, Article 10, Sub-Article 1. So it should not be lost to anybody that the application of the Constitution in decision-making is entirely in the province of the courts. This Senate, on this particular issue, you are seized of this matter. It is an exclusive jurisdiction that is granted to the Senate to undertake a trial for the impeachment and removal of a deputy governor or governor or deputy president or president. This is an exclusive jurisdiction that even the courts have spoken about many times. The courts can intervene in limited and justified occasions that merit their intervention. But it should never be lost that this is the trial court, if I may put it that way. And we also come here knowing that the Senate now is a repository of the law in regard to impeachment. All the cases involving the impeachment of governors and deputy governors that have gone to the courts have involved the participation of the Senate. So if ever we are to talk about a repository of the law regarding removal of state officers by way of impeachment, it is the Senate. And it should not be lost historically from comparative studies of various jurisdictions why this role in our constitutional design was left to the Senate. It was a decision by the framers of our Constitution that this should be an exclusive matter to be dealt by the Senate. Having said that, I was advised by the leadership of our National Assembly, who are our clients, to read a certain passage from the Bible. I think I have a copy here. Yeah, I'm so sorry. I had to carry this particular Bible. I was so advised. And this is, I read the Bible a lot to myself, but never in this kind of occasion. And this is in the book of Exodus 22, verse 22 and 23. And I read both the St. James Version, which is the one I prefer because of the language, and from the Living Bible, which is in English is more appropriate. And I read, that is from the King James Version. Ye shall not afflict any widow or fatherless child, and my wrath shall wax hot, and I will kill you with a sword, and your wives shall be widows, and your children fatherless. From the Living Bible Version, it reads as follows. The language is a little bit more palatable. You must not oppress, or you must not exploit widows or orphans. If you do so in any way, and they cry to me for my help, I shall surely give it. And my anger shall flame out against you, and I will kill you with enemy armies, so that your wives will be widows and your children fatherless. This is the Lord of the Old Testament. Now, I will come back to this matter later. But for now, I want to walk a constitutional journey with the Senate in giving a panoramic view of what our constitutional order is in regard to the office of the President and the Deputy President. Under the old Constitution, we had no provisions like the ones we have in this Constitution. But this Constitution, and I want to persuade the Honorable Senate, it does not just address rights as contemplated in the Bill of Rights, but it also addresses fears. Fears out of a long struggle and experience of the people of Kenya. And the Kenyan people having given themselves this constitution, they were addressing rights and fears, and more importantly, they wanted to establish a system of government that can work. And with that, I want to take the Senate to Article 75 of the Constitution, just to draw the attention of the House of the seriousness of the matter we are dealing with, which is provisions in relation to oath of office of state officers. 74. Before assuming office, before assuming a state office, acting in a state office, or performing any functions of the state office, a person shall take and subscribe the oath or affirmation of office in the manner and form prescribed by the third schedule or under an act of Parliament. Mr. Speaker, I want to take you to that schedule, and I want to draw a difference, a distinction between the oath of office that is administered to the President and the Deputy President, as opposed to the other oaths that are taken by other state officers, including members of Parliament. And there's a big distinction. And when it comes to the oath of the due execution of office for the President and that of the Deputy President, which is found in the third schedule of the Constitution, there are words there that I would plead to the Senate to consider in consideration to the matters which are raised in the motion of impeachment by the National Assembly and the charges as they've been read out here. Now, the motion, the oath for, or solemn affirmation for due execution of office for the Deputy President reads as follows. I do swear solemnly affirm that I will always truly and diligently serve the people and the Republic of Kenya in the office of the Deputy President. I pause there to emphasize those words that are found in the Constitution, that I will always truly and diligently serve the people of Kenya, that is the Republic of Kenya. And it continues to say as follows: that I will diligently discharge my duties and perform my functions in the said office to the best of my judgment, that I will at all times, when so required, faithfully and truly give my counsel and advice to the President of the Republic of Kenya, and that I will do justice to all without fear. I emphasize the word doing justice to all. Those three words in the oaths and affirmations for due execution of office, which are found in the third schedule, are not contained in similar words when it comes to the Speaker of the Senate, the Speaker of the National Assembly, the Chief Justice. It only applies to the Deputy President and the President. Why am I saying this? Because if you look at the Constitution in terms of the election of the President and and the Deputy President, you'll find that, Mr. Speaker, sir, that the President and the Deputy President are elected at constituencies. At constituencies. And in that election, they must receive a majority of votes in at least half the constituencies in the Republic of Kenya. What I'm not trying to say, it has come out, and I say this with utmost respect, that the Deputy President, who stands here on trial by the Senate, would assume that he was elected to represent the interests of a certain region. Whereas the Constitution is clear, he's elected by the whole country. He's got no area to protect. Under the old Constitution, the President had to be elected from a constituency, a Vice President had to be elected from a constituency as a Member of Parliament. This Constitution has no similar provisions. And now when you come to the functions of the Deputy President, and I think this is extremely important in the kind of relationship that there should be between the President and the Deputy President. It says so in the following words, which I need to read for clarity in terms of the Deputy President. And those are found in Article 147, that he shall be the principal assistant, deputized for the President in the execution of the President functions, and also he may be assigned duties by the President. The kind of symbiotic relationship that should exist between the President and the Deputy President is underlined in this Constitution. Now, it is uncontestable, and I think this is the issue that I want to deal with in some detail. It is uncontestable from the record that you have, even from the Deputy President, that the words he is accused to have uttered, where he alleges that Kenya is like a company existing of shareholders, that does not sit with the Constitution of the Republic of Kenya. Kenya is not a republic that is established on the basis of shareholding. It's a republic of citizens. So when a Deputy President talks about taking the interest of Watu Murima, for whatever that would mean, it is not in compliance with his constitutional remit. And the words are there. What he has said in public on this issue is very clear. The second issue is on the question of collective responsibility. You would find out from this Constitution that in nearly all the important constitutional bodies established under the Constitution, the Deputy President is a member of those particular institutions or organs, like the National Security Council. So one would wonder where even the issue of the Director of Intelligence would be discussed in a public forum by the Deputy President when he is the second in command in the National Security Intelligence as established under the Constitution. So I would want, and I plead with the Senate, look at the utterances of the Deputy President vis-a-vis his role under the Constitution. And he has even said that where he has said certain things that are deemed to be insightful, that is protected speech. It cannot be protected speech under our Constitution, because under Article 33 of the Constitution, because of what we have undergone as a nation, Article 33, sub-article 2, has a limitation that the expressions that extend to propaganda for war, incitement to violence, hate speech, advocacy of hatred, that cannot be protected speech. Now, the other very important point, which I want to put before the Senate, sometime in February 2017, the Deputy President traveled to London. And he went to a hospital in London where his brother was admitted in ICU. When he arrived the next day, he prevailed upon his brother to execute a will. That was on the 17th of February, 2017. In that trip, there is no evidence at all that he tried to talk to doctors or physicians who are looking after his own brother. After this visit, he walked away. And 7 days later...
Mr. Speaker, I rise to raise an objection.
Can I proceed?
Mr. Speaker, we owe the Deputy President very elementary decency. We owe it to the Deputy President to be basically decent in these proceedings. I want to know whether counsel at the bar, one, can adduce this kind of evidence that is not contained in any evidentiary material before the Senate. I want to know which ground in the 11 grounds in the impeachment motion is this evidence from the bar supporting. I repeat, Mr. Speaker, we owe the Deputy President the most basic decency. I object.
Senior Counsel Orengo, those apartments, are they contained?
They are contained, they're all here.
And refer to the document.
Volume 4. I am not referring, because if I were to refer to every document, it will take a lot of time, and I have only 30 minutes. If you look at Volume 4 of this document on public participation, from page
Volume 4 of the National Assembly.
Of the National Assembly.
Pages?
Pages 114 to... Yes. And in fact, this page is also called 10 the will. And the Deputy President is the one who is relying on this will. The death certificate is contained on page 119. And it shows the only person who attended the deceased, the brother of the Deputy President at that time, was his daughter, was the only person present. And then there's the will. And in the documents on page 128, and this is why I was raising this matter, on page 128, there's a letter by Mr. Madenge and Mr. Njoroge Rigeru, who together with Mr. Rigathi Gachagua were the joint will executors. And they're complaining about the conduct and action of the Deputy President as an executor of the will and a family member of the late Nderitu Gachagua. On page 129, paragraph 8, there, and it says, from bank statements to this, for this account seen by us, you transferred some funds from these accounts to other persons as follows. On the date when Nderitu Gachagua died on the 24th, the Deputy President was already withdrawing money. On the day he died. On the day he died. And that day when he died, he was there only with his daughter. And then they say on the 19th of May 2017, Again, another money was withdrawn and paid to Messrs. Euro Investment Limited. This story, you will find it in the documentation. And part of it is what Mr. Njomo was saying.
Counsel for Deputy President, just have your seat. When your time comes, you'll be able to make the rebuttals. Proceed, Senior Counsel.
How many minutes do I have?
Mr. Speaker, I respect your direction. I'm willing to take a seat right away, but just to point out something. The document you are being referred to is the document you held in abeyance because it was given to us later for purposes of our consideration. That's number one. Number two, Mr. Speaker, you remember that my learned colleague talked about how my client traveled to London, how without talking to any doctor. These are factual claims, Mr. Speaker, that are just coming from the bar. Mr. Speaker, number three, the opening statement speaks to the motion and the grounds in the motion. I beseech this House direct that parties restrict themselves to the motion and the grounds in the motion. The facts you are now being referred to have no basis in the motion and the grounds in the motion, unless Senior Counsel, His Excellency Governor Orengo, can draw your attention to any ground in the motion that those facts are not addressing. I repeat what I said, Mr. Speaker, the ruling is yours. We owe it to the Deputy President and the integrity of our checks and balances institutions to maintain basic decency in these proceedings. I rest.
In fact,
Counsel, I cannot tell you how you're going to make your opening statements. If you're going outside the allegations, that's up to you. The senators are here listening, and they'll be able to make the necessary decision at the end of this. Now, Senior Counsel Orengo, there's an environment that you've made that the Deputy President of the Republic of Kenya, on a certain date that you indicated, traveled to London.
yes. The evidence is...
his sick brother.
Yes.
And on the side of the sickbed, he made his brother sign a will. Is that contained anywhere in the documents from the National Assembly?
My Lord, Mr. Speaker, if you look at volume 4 from the pages that I indicated, right from page 113, it shows what flight he took, at what time, a British Airways flight on the 16th, and arrived in London on the 17th. The only business that comes out from that document and his documents is that he got a will signed, and there is no further evidence of his activities in London until 24th, when the only activity in which he didn't participate was to be present when his brother died in London. But all this I'm saying in relation to the allegations that we have against the Deputy President.
Mr. Speaker, sir.
No, Counsel, ordinarily,
Yes.
no objections are raised during the 30 minutes of the opening statement. Ordinarily. I have tried to accommodate, but now you're stretching my generosity a bit too far. Allow Senior Counsel Orengo to conclude. In your opening statement, you may choose to make a rejoinder.
What I want to conclude is this. From what I've said, from the way his brother's accounts were raided, that was continued to the time when All Life Guidance was acquired for a sale by proxy of 412 million shillings. He bought a property in Nyeri, the Outspan and Treetops, for an amount exceeding 800 million shillings. And we're saying part of that money was not money coming from him, and evidence will show that he was raiding monies that truly belonged to the estate of his late brother to acquire property. If that is not an offense by law, these were proceeds of crime committed by the Deputy President to acquire property. And to drive this point home, the judgment by Justice Minor, which is also part of the record, where she made a determination, and that judgment stands, that the 200 million shillings that was found in an account with a financial institution, in excess of 200 million shillings, were proceeds of crime. And that 200 million shillings, again, the documentation here, if you look at it and we show it in evidence, was the same money that was used to acquire Treetops and Aberdares as part of the money that his sons were able to use to acquire those properties. So we are saying that the acquisition of these properties came out of criminal conduct, and all the particulars of the criminal conduct is found in the documents that were presented before the Senate. Now, Mr. Speaker, I think that it is critical that we look at the authority of the office of the Deputy President vis-a-vis that of the President, the doctrine of collective responsibility. And I showed why the office of the Deputy President is so important in carrying certain functions so long as he lives to the true spirit of the Constitution. Many times, and the incidents have been shown, acts of insubordination, like when he issued a press statement in Mombasa after the President himself had issued a statement that went contrary, absolute insubordination to the President, who is his boss. And if really one can talk about insubordination, that was an act of insubordination. Lastly, the other issue that I need to bring out quickly is that the Constitution and the Senate is aware of the fact that at the end of, at every 5 years, you pass a basis for allocation of resources here in the Senate. And they abide by certain principles which are contained in Article 203 of the Constitution. This issue about certain areas being preferred because they're shareholders goes against the very spirit of the Constitution. Or the notion that people can be appointed into government on the basis of how they voted or on the basis that they are shareholders, that is not again borne by the Constitution, because the executive authority that is granted to the executive requires that even in allocation of revenue and appointment of people to serve in the public service must depend on regional balance. So to talk about shareholders, to talk about some people being able to reap on the basis of shareholding, that is repugnant and in conflict with the provisions in our Constitution. Now, Mr. Speaker, I would want to say this with all the seriousness it deserves. This Constitution is supposed to work. It's supposed to work. And it can only work if state officers are compliant with the provisions of the Constitution.
2 minutes to wind up.
Yeah. Well, if they're compliant with the provisions of the Constitution. The doctrine of collective responsibility and the authority of members of the cabinet spring from the fact that they are all individually and collectively responsible to the President. If that primary principle cannot be applied, then it will be difficult for any government elected to function in a manner that it can deliver services to the people of the Republic of Kenya. So I urge this Honorable Senate that having painted that large picture, the next phase, when you are now going to listen to the evidence and look at the exhibits that we have attached, you will find that a strong case has been made out for the impeachment and removal from office of the Deputy President of the Republic of Kenya. And this Senate should not shy away from undertaking that responsibility. It does not matter that there is a matter that could be taken to DCI or to the AACC. The role of Senate is different, to undertake oversight over those who are given a responsibility to manage the affairs of the country. And that does not depend on the role of any other agency or body created by the Constitution. Your role is to demonstrate to all people in state offices that this oversight role that you play, whether it is that of impeachment, to demonstrate to the people of Kenya that it is not cosmetic. And where there's evidence, like the evidence that we are showing and adducing before you, that person.
I'm afraid, Senior Counsel, your time is up.
Should suffer the consequence. I thank you. I thank you.
Counsel for the Deputy President. The floor is yours.
Thank you, Mr. Speaker, sir. and thank you, distinguished senators. My name is Elisha Ongoya. I stand here to make the Deputy President's opening statement. Allow me, Mr. Speaker, sir, distinguished senators, to open by reminding us some fundamental principles. We are sitting here today as a Senate to discharge a constitutional mandate. And before you are given the cudgels to start discharging any mandate in this Senate, the Constitution demanded that you had to take an oath of office before you do anything else. I now understand better why that oath of office was prescribed and why it was framed the way it was framed. The Deputy President reminds you the following terms in your oath of office before you assumed office to discharge the functions of senators. You have to bear true faith, and allegiance to the people and the Republic of Kenya. You have to obey, respect, uphold, preserve, protect, and defend the Constitution of Kenya. And you have to faithfully and conscientiously discharge your duties as members of the Senate. I submit respectfully that the case regarding the proposal to remove the Deputy President from office by impeachment may appear to put the Deputy President on trial, but that is only in the most technical sense of this process. At a more significant level, what is on trial throughout these proceedings is the resilience and steadfastness of our Constitution, our constitutional institutions of checks and balances, and actually their capacity to withstand any form of waves and pressures. That is what is truly on trial. His Excellency Rigathi Gachagua beseeches this House to keep in mind that we have a constitution, a constitutional order, and a constitutional democracy to protect as we conduct these proceedings and as we make decisions in these proceedings. He asks you that at the end of this exercise, let our constitution, our constitutional democracy, and our constitutional order emerge stronger. Allow me to address this House on the defined standard for impeachment of the Deputy President. In a comparable decision by the Supreme Court of Kenya, the case of Honorable Mike Mbuvi Sonko versus the Clerk, County Assembly of Nairobi, and others, the Supreme Court observed as follows, and I quote, "It must, however, be stressed for the avoidance of doubt that the power of impeachment, removal, or recall is not one expected to be in constant or frequent exercise. It is only in the face of credible evidence of extraordinary wrongdoing that the conduct of a state officer will be investigated, and even then, only upon sufficient proof of the allegations that the impeachment, removal, or recall would be warranted." Two questions we pose must constantly linger in your minds, distinguished senators, as you undertake the assignment now before you. Question number one, we beseech you to bear in mind the question, is there credible evidence of extraordinary wrongdoing on the part of His Excellency Honorable Rigathi Gachagua before you? Number two, is there sufficient proof of the allegations leveled against His Excellency Rigathi Gachagua? Article 150, Clause 1, Paragraph B, sets out the grounds for removal of a Deputy President from office by impeachment. These grounds are, number one, gross violation of the Constitution or any other law. We emphasize the drafter's use of the word gross. Serious reasons to believe that the Deputy President has committed a crime under national or international law. Again, we emphasize the word serious, then gross misconduct. Surmises, conjecture, street rumors cannot pass muster. This conduct must be the conduct of the person of the Deputy President. It is sufficiently notorious for this court to take judicial notice of when the late Nderitu Gachagua, whose will is now referred to here, died. You are told to investigate the conduct of His Excellency Rigathi Gachagua at a time, or at the time around which his brother, His Excellency Governor Nderitu Gachagua, as he then was, died. It is sufficiently notorious that His Excellency Rigathi Gachagua was not Deputy President of the Republic of Kenya. But that's not enough. You will peruse the motion before you with a view to finding which ground in that motion is sought to be established by these allegations around what may or may not have happened around the time the late Nderitu Gachagua died. You will find absolutely no ground supported by those allegations. Let me disclose here. It is designed to whip your emotions. It has no other purpose. Looking at your oath of office that I've alluded to, there is no room for your emotions to be whipped as the basis of decision-making in any act that you engage into in the discharge of your constitutional mandate and responsibilities. What does our Constitution expect of the mover of the motion in proceedings of this nature? Our Constitution expects the mover of the motion to make allegations of any or all the grounds set out in Article 150, Clause 1, Paragraph B of the Constitution. And to begin by submitting, it is true that the mover of this motion has written down some allegations in Volume 1 of the documents from the National Assembly. Secondly, the mover of the motion is thereafter expected to supply credible evidence of an extraordinary wrongdoing and sufficient proof of the allegations against the Deputy President. Mr. Speaker, sir, distinguished senators, we submit that is where the mover of this motion ought to start having problems with this House when he's called upon to account. It is the submission of His Excellency Rigathi Gachagua that the motion now before you has fallen short of the threshold set by law by multiple miles. When you examine the material before you, you will discover that it will oscillate between the following categories of stages. One, you will have material before you that is just plainly false. Then from falsehood, it will go to the ridiculous ones. And I'll demonstrate that shortly. There will be ridiculous claims here. Then finally, it will end up into embarrassing claims. Allow me, in the few minutes I have, to just do a sneak preview of some of these claims so that we have an overview of the case that is before you. At paragraph 74B of the first volume, which is the impeachment motion, you will find an allegation of this nature that His Excellency Rigathi Gachagua has influenced his family members, allies, associates, and proxies to take control of a local cooperative society in Madeira, which they are financially hemorrhaging. Number one, no name of any family member is supplied in the allegation or in any of the evidentiary documents before you. No name of any ally is supplied in the motion or in any of the documents before you. No name of any associate is supplied, even a false name, none, is supplied in the motion and in the documents before you. No name of any proxy is supplied in the motion or in any of the documents before you. The name of the alleged circle is not identified. You can imagine, Mr. Speaker, sir, distinguished senators, being called to defend yourself on a claim that you have taken over through your associates a circle that we don't know. Told now come and defend yourself. I began by saying some of these claims are either ridiculous or embarrassing. Secondly, at paragraph 74A, you'll be told that His Excellency has connived with cartels in the tea sector to block the Kenya Tea Development Agency from implementing guaranteed minimum returns that will benefit tea farmers. No statement, no affidavit, no correspondence from any official of the Kenya Tea Development Agency is before you. No complaint to any agency, no complaint to this parliament by any official of the Kenya Tea Development Agency is before you. It's just a claim which the mover of this motion said before the National Assembly, and surprisingly, to those of us who have some residual faith in our institution, he told the National Assembly, just believe my word for what it is. And when we thought that was a joke, we got a joke lifted a notch higher. The National Assembly actually just believed his word for what it is. No evidence. Nothing in the affidavits before you addresses anything about the Kenya Tea Development Agency. Nothing in the 5 affidavits before you. Let's progress, good people. Paragraph 72 of the motion before you states that His Excellency has persistently undermined, demeaned, and committed insubordination instead of assisting the President. And let's face it, Mr. Speaker, sir, distinguished senators, if you accuse somebody of insubordination, the only person who can complain of being insubordinated is the supervisor. No statement from the President, no affidavit from the President, even no witness summons to the President has been sought here to call him to complain he has been insubordinated. The Deputy President, when he received this motion, wrote to the Secretary to the Cabinet, requesting to be supplied by all assignments given to him by the President and any that he has not delivered. To date, as we stand here, we have not received a response to that letter. And yet we shall be told, just believe the mover of this motion, the Member of Parliament for Kibwezi West constituency, that when he is oscillating between the National Assembly and Kibwezi West to serve his people, he knows better than the supervisor of the Deputy President that the Deputy President has insubordinated his boss. I began by observing they will move from the false through the ridiculous to the embarrassing, and these are the claims before you. At paragraph 64, paragraph A of the impeachment motion, you will be told that His Excellency the Deputy President said that he will present a petition for the removal of Justice Esther Maina from office, which he has not done to date. Mr. Speaker, sir, my eyes are normally problematic, so I will not know the time allocation.
15 minutes.
Thank you so much, Mr. Speaker, sir. The claim is that His Excellency publicly said that he will present a petition for the removal of Justice Esther Maina from office, which he has not done to date. That's the complaint. Evidence is before you that there is a pending complaint by His Excellency the Deputy President before the Judicial Service Commission. So the mover of this motion first has perjured himself in his affidavit by saying that each of these facts are correct, when this fact is false by evidence available. You will find that paragraph 34 of the motion before you, it says that His Excellency falsely threatened to file a petition for removal of Justice Esther Maina. How can the Deputy President be accused of falsely threatening when in fact he has filed the complaint? Where is the falsehood when there is a pending complaint? That complaint is before you in the Deputy President's documents for your own perusal. I began by saying they'll move from the false through the ridiculous to the embarrassing. At paragraph 78C, you'll be told that His Excellency routinely summons procurement officers in ministries and state institutions and instructs them to direct procurement of goods and services in a specific manner. No officer from any ministry will swear an affidavit claiming to have been summoned to award any procurement for any goods or any services in a particular manner. In fact, what you'll have before you is actually very ridiculous. You will be told that there was a tender for supply of mosquito nets that was cancelled in May 2023. Then a local company that was an agent of the supplier was following for the return of its bid bond in July, 2 months after the cancellation of the tender. How can you influence a tender that was cancelled 2 months ago? I told you it will move from the false through the ridiculous to the embarrassing. Now, the more interesting one is at paragraph 78A. You will be told that His Excellency bullied Kenya Medical Supplies Agency officials into awarding a tender for the supply of mosquito nets to Crystal Limited. Good people, Crystal Limited was not even a bidder for that tender. He pressurized people to award it to somebody who is not even a bidder for that tender. I observed it will move from the false through the ridiculous to the embarrassing. Those of us who understand this motion for what it is, understand why these panel-beating maneuvers are being tried here. The motion as presented and approved by the National Assembly will remain in our constitutional history as the most embarrassing motion ever approved by a House of Parliament in the Commonwealth. We respectfully submit. You'll be told at paragraph 58 that His Excellency is reasonably suspected to be the principal beneficiary of what are called dubious transactions by Lusona Events Limited. You will then go to the allegations on Lusona Events Limited, and you want to see those transactions, how are they terminating to the deputy president? You'll not come across any connection. They'll just say, a director of this company withdrew some money from his own company. The deputy president is a director. None of his family members are director. That person withdrew money from his company, bought a motor vehicle in his own name. The mover will say, I'm therefore drawing a reasonable conclusion that the deputy president is the beneficiary of this. Good people, the word reasonable has meaning known to law. I submit very respectfully that this falls short of the definition of the word reasonable suspicion. I submit it actually gravitates towards unreasonable suspicion. Now let's look at this. You'll be told that His Excellency has acquired 40 acres of land in Kakuret, Kambraini, in Nyeri. Evidence before you will show that this is land that the deputy president in fact bought from a current member of the National Assembly. So he knows that member. In 2015, before he even joined state office as a member of parliament, you are told that the purchase of this land in 2015 shows that in the last 2 years, the deputy president has amassed immense wealth. I began by saying, let's be elementarily decent. One of the most frustrating things about preparing for such a hopelessly conceptualized, hopelessly crafted, and hopelessly presented case is that you begin doubting yourself because you begin wondering, what am I not seeing? Land bought from a sitting member of the National Assembly in the year 2015 is supposed to be evidence that in the last 2 years, His Excellency Rigathi Gachagua has amassed immense wealth from the office of the president to acquire that property. Now, let's look at paragraph 45G. You'll be told that His Excellency has acquired 80 acres of land in Meru County. No land registration number is provided. Not even an affidavit of a neighbor who says, I know yes, this land is my neighbor. Just an allegation by the mover of this motion like that. And the Swahili say, ukistaajabu ya Musa utaona Firauni. This mover of this motion stood before the National Assembly and said, just believe me for this statement as it is. The first joke. The second joke, the National Assembly actually believed him and approved the motion. You'll be told that paragraph 45H, that His Excellency has acquired a dairy farm in Nyandarua County. Now, I guess we all have a common understanding what a dairy farm is. His Excellency has no dairy farm in Nyandarua County. The move of this motion does not give us any evidence of this dairy farm in Nyandarua County. You'll be told that His Excellency has used the office of the Deputy President to corruptly influence unnecessary and expensive renovation of his official residence in Karen and Mombasa. What will shock you is this, good people. The contract for the renovation of the official residence of the Deputy President was signed by the controller of State House. Unless the move of this motion wants to make a claim that the Deputy President conspired with the State House to have this contract executed. Number two, it will be known to all of us as members of Parliament that the money for renovation of this official residence was approved by the National Assembly. Is the National Assembly conceding that it approved money for unnecessary expenditure by government? How can the National Assembly approve money for use for renovation of the residence of the Deputy President, then after that money is used for the intended purpose, the renovation of the official residence of the President, now drag the Deputy President for impeachment for the reason of that renovation? I said it will move through the ridiculous to the embarrassing. You'll be told that the Deputy President has a helicopter landing facility at his land, Ruguru, Kiamariga, 1223 in Madeira. The Deputy President simply has no helicopter landing pad on that farm, a small parcel of land with napier grass, unless the mover of this motion can now convince us that new technology has emerged, that napier grass is the constructing material for landing pads for aircrafts. That's the only way it can make sense. But because it doesn't make sense, good people, you'll agree with me, it moves from the false through the ridiculous to the embarrassing. Now let's deal with it. You'll be told the Deputy President has amassed a wealth portfolio amounting to 5.2 billion shillings. Elementarily, we must then look at the particularization. Tell us which one is what plus which one is what plus which one is what to amount to this 5.2 billion. This figure, the origin, is only known to the mover of this motion. There is nothing on the body of the motion. There is nothing in the documents attached to the motion There is nothing in the video clips to be played by the mover of this motion that tells us mathematically how he arrived at this figure of 5.2 billion shillings. Then when the charges were read, distinguished senators, you had some 22 companies being read one by one. Thank you. 22 companies. A number of things will surprise you. You'll just find a company listed called Spiritway Limited. Nothing in this motion tells us what wrong has this company done. Nothing in the motion, completely. It just listed that way it is. Fortis Vis Group Limited. Nothing in this motion tells us what wrong has Fortis Vis Group Limited done. They're just companies whose names have been listed, and we have spent the taxpayers' money this afternoon listening to these companies' names being written with nothing in this motion telling us. So what wrong has Dorcas Rigathi Foundation done? What act are you complaining of for that company? What omission are you complaining of in respect of that company? Heartland Supplies Limited, you just find a name of a company there. No wrongdoing is alluded to it. No allegation is made against it. They're just companies thrown there. Distinguished senators, the Romans called their assembly, which was the equivalent of this Senate, the patres. It was an advisory council. That name was derived from an old Latin word meaning father. Senate derives its name from the Latin word senex, meaning old man. All these words are supposed to address the sagacious, the state of wisdom of the Senate. If this Senate lives true to its historical origin as the patres, if this Senate lives true to its Latin origins as the senex, the old man, the wise man, it will see through these lies, it will see through this ridiculousness, it will see through these embarrassing statements. If time were to permit, I will take you through other allegations that meet the same test of falsehood, ridiculousness, and embarrassment. Fortunately for us, the rules of procedure permit us to cross-examine the mover of this motion and the respective witnesses as a way of bringing forth these lies much more clearly. We shall do that when the time presents itself. At the end of it all, we shall beseech you to do two things: to be true to your oath of office as senators, to be true to your oath of office as senators, to pour through this evidence, to listen keenly to this evidence, to make a decision premised on the evidence as tested here in cross-examination. And if you do that, we have no doubt in our mind, you will reach the same conclusion that what has been presented before you as a most consequential motion, perhaps in our lifetime, is false, is ridiculous, is embarrassing. I rest the governor's opening statement.
That is the Deputy President, Council. It's not the governor.
My apologies, Mr. Speaker. I have been here multiple times on governance, and I think that is what was reigning in my mind. I rest the Deputy President's opening statement. My apologies for that.
Very well.